Morning, Your Honors. May it please the Court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under Appellant's seat. There were only 4 people in the car. Pete and Harris both identified Appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, "Help, Tory shot Meg, 911. Harris again ID'd Appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified Appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than Appellant fired the shots. Now, there's 3 times in which Appellant tacitly admitted being the shooter. The first is hours after the shooting, Appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote-unquote shit that he did. Now, the second one was later that day, Appellant sent a text to Pete, to the victim, and that text was preserved. In it, Appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote-unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, Appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told Appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, Appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as Appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, Appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was Appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in Appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that Appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for Appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Let me ask a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was, Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call. So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontations clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that if the defense counsel wanted more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
Any rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medessian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty, but I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance in testimony where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, you know, it wasn't Miss Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Miss Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, you know, Mr. Medessian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medessian said, but procedure, and the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And that's, I can't speak for Mr. Medessian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medessian very respectfully did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And then because of that, you know, that's why I reminded the court that he had that very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that, I submit.
All right. Thank you both very much. The matter stands submitted.